Everyone, my name is Shelly Anand. I'm a supervising staff attorney with Tahrir Justice Center here in Atlanta. And welcome to, I think this is now our, I think it's our second or third, I can't remember now, series training that we've been doing as a part of a series for the summer interns and practitioners in the Atlanta area doing immigrant rights work. We're really lucky today to have two really awesome immigrant rights attorneys from the Georgia Asylum and Immigration Network who are going to be talking about different forms of relief that immigrant victims and asylum seekers can apply for. And I'm hoping we can save some time at the end for Q&A. If you guys have any questions, feel free to put any questions you have in the chat and I'll try to keep track of them. And then ladies, maybe the last 15 minutes or so we can allot to those Q&A. I'll ask everyone to make sure they've muted themselves. Take a moment to do that. I'm going to have to do that because I have two very loud children downstairs and they tend to scream. So I don't want to make sure our speakers don't get interrupted. The other thing I would really appreciate, and all of the orgs doing these trainings would appreciate, is if you can go into the chat, quickly introduce yourself with your name, the organization you're with, or what law school you're with, or anything like that. That way we can kind of know who all is joining us. So before we get started, I'm just going to quickly introduce our two fabulous speakers. First, we have Serene Hawasli Kashlan. She's an asylum attorney at GAIN, representing asylum seekers affirmatively before the U.S. Customs and Immigration Services and defensively before the Executive Office for Immigration Review. In addition to direct representation, Serene mentors and provides training and support to volunteer attorneys representing GAIN clients seeking asylum. She's a graduate of Georgia State University with a bachelor's in political science, concentration in international affairs, and she earned her law degree from GSU College of Law. After law school, she worked at an estate planning firm in Troy, Michigan, and she volunteered with various pro bono organizations there, including the Family Law Assistance Project and the Michigan Immigrant Rights Center, providing pro bono services to Syrian nationals seeking temporary protective status, or TPS, visa extensions and asylum. Prior to returning to Atlanta and joining GAIN, Serene was a solo practitioner and an independent contract to a Detroit-based immigration law firm, representing clients in the areas of immigration law, family law, and estate planning. Serene is licensed both here in Georgia and in Michigan. Next, we have Carla Diaz, is the Victims of Violence attorney at the Georgia Asylum and Immigration Network, or GAIN. She was born in Guadalajara, Mexico, and grew up just south of Atlanta. She received her BA in criminal justice from Georgia State University. She began working at GAIN as a legal extern in the summer of 2017 and transitioned into the Victims of Violence attorney role after she graduated from law school in December of 2017. In this role, she provides representation both directly and by recruiting and training volunteer attorneys to represent immigrant victims of domestic violence, human trafficking, physical and sexual assault who need assistance with TU visas and VAWA self-petitions. Carla also participates in outreach events with other community partners, bringing awareness to immigrant issues and informing the immigrant community of their rights. So please join me in welcoming these two amazing speakers. And for our interns, just see, Carla started as an intern and now she's working and presenting to all of you. So this is your future, hopefully. So thank you, Carla and Serene, both for being with us today and for this presentation. And with that, I'll let you get started.
Thank you so much for coordinating. We really appreciate it. And welcome, everyone. We're happy to have you here. 1 minute while I pull up the PowerPoint. Can everyone see that?
Yep, you're good.
Okay, great. Well, again, my name is Serene Hawasli Kashlin. It's a pleasure to be here today to speak to you about the basics of asylum law. Again, I work for GAIN, the Georgia Asylum and Immigration Network. So I just wanted to briefly speak about GAIN as an organization. We're a nonprofit organization that provides free immigration legal services to victims of violence and persecution. So our vision is safety, freedom, and opportunity for all. We serve hundreds of clients from all over the world. I'm sorry, thousands of clients from all over the world. We provided millions in pro bono legal services. Um, and we basically, this is a roadmap of a case with gain. We would, first have the initial contact by the client. We would schedule in-person consultation for the clients that we don't refer out. And then we would screen these cases, and if appropriate, we would find and train, recruit and train volunteer attorneys to take these cases and place them with a volunteer attorney. And so we work on a dual representation model where we represent cases directly, and we also place cases with volunteer attorneys and provide mentorship and ongoing technical assistance to our volunteer attorneys. We believe that pro bono impact is greater when we have others from the Atlanta legal community serving these well-deserving clients. So I just wanted,
Sorry,
yes?
are you changing the slides? Because I don't know if it's just me, but I can just see the, okay, now it looks,
Are the slides not changing?
wait, it looks static for a minute. Was that the same for you, Shelley? Did it look like she was just still in the
On the
editing
first,
mode? Yeah,
yes. So maybe
okay.
click the present or whatever
Yeah.
Okay.
and then you can click through that way.
I was actually, that's,
Hmm.
let's see.
You're receiving. Hmm,
I apologize.
no problem.
Can you guys see a new slide, or are you seeing the first slide still?
So I'm seeing the how do people immigrate to the U.S., but
Okay, that's the
is that what
correct.
you're on? So
Yeah.
are you presenting it or are you in the editing software?
I believe I am presenting it.
Okay, see, I don't think I see that. So you hit play or I guess present
Yes.
presentation.
Yes. And I'm going to go back one slide. Can you see that slide?
No.
No, it didn't look like it changed.
Do you want me to try?
Sure, that would be great. I
Okay.
apologize for that.
No, that's okay.
I know.
Oh, great. My computer's freezing now.
I can try to pull it up too. I have it too.
I changed the slide like 5 times. Were you able to see any of the changes?
Well, we could see on the left because you had it kind of like in that open
Oh, okay.
where you could see them, but I knew what you were talking about, but I was like, wait, I don't think they're showing up.
Okay, here, let me see if I can share my screen with you guys. Hold on just a second. Okay, and then I'm going to play it. Oh, this is for the TVSA one.
Yeah.
Did you guys send me 2 separate slides?
Yes. So let me see if I can pull it up because Serene's actually had to send us a Google link because it was too big. So
Oh.
I'm trying to pull it up now. It's just also taking its time.
I apologize.
No, it's okay. Hey, we're all working remotely trying to figure it out.
Yes, trying to manage this. Okay, hopefully it's coming up now.
This way.
Okay,
In
so
person.
let me try sharing now. Okay, let me present and tell me if you can see it.
I was on slide 6.
Okay, come on. Okay, can you see?
Yes.
Okay, so I believe you were here.
Slide 6, the next one. Yep. Yeah, right there.
Okay, there we go.
Well, no, the next one, Carla, sorry.
No problem.
There we go. Okay, that's where I left off. Basically, how do people immigrate to the United States? These are the three major ways, either through business sponsorship or through family members that are U.S. citizens or legal permanent residents. And then we have people that immigrate to the United States because they are seeking humanitarian relief. Next slide, please. So that's our focus at GAIN. We are, organization focused on helping asylum seekers with their immigration process. Next slide. So I wanted to first explain the difference between a refugee and an asylum seeker. So a refugee is someone that is applying for relief from outside the United States. They are processed and screened through consular processing, and they also receive benefits upon arriving to the United States. However, an asylum seeker is someone that is applying from within the United States. They're physically present here, and they are applying either with the USCIS or Immigration Court. I'm going to explain the difference between affirmative and defensive asylum shortly. And while their case is pending, they are able to live and work in the United States. However, they do not receive benefits unless and until their asylum is granted. So this gives you a little map or overview of how refugees get to the United States, or asylum seekers, basically. So as I stated earlier, refugees are processed abroad. Some asylum seekers, they flee persecution, they enter on a valid visa. That's when they would apply affirmatively with USCIS, the United States Citizenship and Immigration Services. There are people that flee persecution and they asylum at the border. Credible fear interview, they're able to be in court proceedings and apply for asylum defensively. And same goes for people that are here. Maybe they overstay their visa, or they don't present at the border and they sneak in and then they're put in removal proceedings by ICE. Then they would also be able to apply for asylum defensively. Next slide, please. So what is asylum? I know everyone has a general idea of what asylum is. Someone that's afraid of returning to their home country. They're fleeing, violence, persecution, and they want to seek a new life and safety in a new country. So legally speaking, it's discretionary relief for people fleeing persecution, and they must meet the statutory definition of a refugee. So what is the statutory definition of refugee? Next slide, please. It is a person outside their home country who is unable or unwilling to return to that country. They are unable or unwilling to avail themselves of the protection of that country because of either past persecution or a well-founded fear of future persecution. And it must be on account of one of the 5 protected grounds. And as you can see them listed here, race, religion, nationality, political opinion, or membership in a particular social group. So as you see on this slide, it breaks down the elements, the legal elements that an asylum seeker must prove. And the burden of proof is on the applicant. They have to show each one of these components. Number 4 is not as apparent on the face of the statute, but the persecution must be perpetrated by the government or by someone the government will not or cannot control. And we're going to discuss each element in turn. Next slide, please. So what does it mean for an applicant to be unable or unwilling to return to their home country? They are afraid. They cannot return to their country, and they're unable or unwilling to seek protection from that government in that country. And basically filing for asylum shows that unwillingness to go back. And of course, we assume that these applicants didn't go back after they were persecuted, unless they have a very good reason. But usually filing for asylum shows that unwillingness. So this is one of the easier elements to prove. Next slide, please. Now, what is persecution? Persecution has to be harm of a serious nature. It has to be more than just mere harassment or discrimination, or even more than just generalized violence. It has to be, serious physical harm, threats to life or freedom, torture, rape, prostitution, emotional or psychological harm could also constitute persecution. And those are easy to overlook. However, when you're interviewing a potential client, it's important to understand the context and to get the full picture. So it's looked at and considered cumulatively. And as you see on the slide, persecution is not only, as stated before, discrimination. It's not only economic hardship or civil war even, or generalized violence. It has to be more than that. Slide, please. So how do you establish a well-founded fear of persecution? So a well-founded fear, there's a subjective component and an objective component. The subjective component is that the fear must be genuine. That must be the applicant's actual state of mind. And the testimony of that applicant is really crucial and important, and the fear must be clear and credible. Now, objectively speaking, it must be objectively reasonable. So someone in the same or similar circumstance would also be afraid, and there must be a reasonable possibility, 1 in 10 chance that persecution could occur. And country condition evidence is crucial to prove this element, that they have a well-founded fear of future persecution. So articles and information on that specific country and why that person would be in danger if he or she were to return. Next slide, please. Now, if the applicant has suffered past persecution, there's a legal presumption that they're going to suffer future persecution. And the burden would shift on the government to rebut that presumption. So either the government would try to show that there's a fundamental change in circumstances in the country and that fear is no longer reasonable, or that the applicant could relocate safely and reasonably within their country. Usually, if the prosecutor is not the prosecutor, the persecutor is the government, there's a presumption that relocation would not be reasonable. So, if that person is afraid of future persecution and the government is the persecutor, it's not reasonable to expect them to reasonably relocate within that country. Next slide, please. So it's important that, like I stated before, country condition evidence show that, or objective facts show that there's a risk of future persecution. And there are other factors to consider as well, such as, is there a pattern of persecution in that country, as we discussed with country condition evidence? Were there specific threats to that applicant? Was the applicant's family or friends targeted? Or does he know others that were in a similar situation that were targeted? Amount of time that passed since the threats happened. Did the applicant return to the home country after the threats? That's an important factor to consider. And can the applicant relocate within the country? Those are all factors that we kind of touched upon in the last slide. Next slide, please. Also, an important element is that the persecution must be on account of one of the protected grounds. So there must be a nexus between the persecution and between the protected ground. And to establish that nexus, it has to be the reason that the applicant was persecuted was because of a particular characteristic. And that characteristic can be actual or imputed. For instance, someone has the actual political opinion, or someone doesn't believe that, the applicant doesn't have that actual opinion, but they're imputed that opinion because they belong to a certain religion or certain ethnic group. That could be an imputed political opinion, for instance. And this characteristic is a protected ground. So you have to establish that nexus between the persecution and the protected ground. Next slide, please. Now, what are the 5 protected grounds? We talked about them earlier, but they are race, religion, nationality, political opinion, and membership in a particular social group. That last one is more difficult to define, and also case law is changing on it. But this is the general definition. It's a group of people who share a common immutable trait that is socially distinct and sufficiently particular. Examples of that would be, for instance, the LGBTQ community, or female genital mutilation victims, or gang-based violence and domestic violence victims, the case law is turning away from that now, but that was in the past considered, a particular social group. It still is, but those cases are harder to win. Next slide, please. Now, just to give you an idea of the types of cases GAIN sees, this graph was from last year. The majority of our cases were people that were persecuted based on their political opinion. There's a sizable group that were persecuted based on their particular social group. And as you can see, religion would be the third category. Race was the smallest. Now, keep in mind, you can have more than one reason that you're being persecuted for, as long as one of them is a protected ground. And that's the main reason that person's being persecuted. That's good enough to seek asylum. Next slide, please. Now, I wanted to talk to you guys about the process, because it does matter. The jurisdiction and the process differs depending on the type of case it is. So there's an affirmative asylum process. There's a defensive asylum process. There is an appellate process, but we're not going to be discussing that today. I just wanted to kind of show it to you in the slide to give you an idea that decisions can be appealed to the Board of Immigration Appeals and even to the circuit court above that. Next slide, please. So to give you an idea of what is affirmative asylum is where an applicant is not currently in removal proceedings. So they entered the United States with a valid visa, and they would apply with the United States Citizenship and Immigration Services. They would have jurisdiction. And this would be an administrative interview by an asylum officer. So it's not a court proceeding. It's less adversarial, or it isn't adversarial. And it has a much higher grant rate than defensive asylum, because the case is heard in front of an asylum officer and not a judge. Also, to note, all applicants must apply for asylum within 1 year of entry, unless there's an exception. Next slide, please. So defensive asylum is it where an applicant is currently in removal proceedings. They can be detained or not detained. And also, so basically the applicant is applying defensively in court. And this is a trial-like process. It's adversarial, where the government is the other, is the opponent. And also, it has a much lower grant rate, especially in Atlanta. Atlanta has the lowest asylum approval rating in Atlanta Immigration Court in the nation. So around less than 5% of asylum cases are granted. And that's why it's so important to do the work we do. Next slide, please. And just to give you an idea of GAIN's cases, this was a statistic from last year. We have a majority of affirmative cases, although currently we are seeing an uptick in defensive asylum cases. Next slide, please. Now, just to introduce this concept, and we do screen for these in the consultation phase of our process. But if a client was, or an applicant was previously denied asylum, if they had a prior order of removal, if they had a safe third country, if they themselves persecuted others, or if they themselves are a danger to the security of the United States, also if they materially supported a terrorist organization, even under duress, or if they committed a serious political crime, these are all bars to asylum, so they wouldn't be able to obtain asylum. Next slide, please. Now, what are the benefits of getting asylum? An asylee, they become an asylee once asylum is granted. They can live and work in the United States. They can immediately petition for their family members, specifically their spouse and children under the age 21, to come to the United States. They are, after a year, they're eligible to adjust their status to legal permanent resident. And eventually, after 4 years after that, they can naturalize and become citizens. They are also eligible for resettlement services or assistance from the government that's available to refugees. Slide, please. even though we're not going to dive deep into these other forms of relief, withholding, any application for asylum is also an application for withholding. Withholding is a mandatory prohibition against returning an individual to their home country if their life or freedom would be threatened. It actually has a higher standard of proof than asylum. It has to be more likely than not. The asylum would be, the applicant would be persecuted. Also, there's limited benefits. They can live and work in the United States, but it's not a path to citizenship. And the applicant may be removed if the country conditions change. Also, it has statutory bars just like asylum. So I find it funny because asylum is easier to prove and withholding is harder to prove, but I guess asylum is discretionary while withholding would be mandatory if the burden of proof is met. Next slide, please. Also, I wanted to mention withholding under the Convention Against Torture. That is also another form of relief, although it has a very low grant rate, about 3%. The proof,
Los vas a tener como ver ahí en el shop. Los tienes que mover tú para adentro.
sorry. It prohibits the removal of an individual to a country where it's more likely than not that he or she would be tortured. So it has an even higher burden of proof than withholding alone. And it's also limited relief. There's no adjustment of status, no ability to travel, also no derivative status for spouse and children. Next slide, please. So why do we need volunteer attorneys? And why does GAIN operate on this model where we train and recruit volunteer attorneys? It's because we want to serve as many people as possible. Non-citizens do not have the right to appointed counsel in immigration matters because it's considered civil. It's not considered, criminal. So there's no right to appointed counsel. So even if they are children, mentally impaired, someone fleeing persecution, victims of trafficking or abuse, they are not entitled to an appointed counsel. And as I mentioned earlier, Atlanta being such a difficult jurisdiction for asylum seekers, it makes it that much more important for people to be represented, for applicants to be represented. Also, attorneys greatly increase an asylum seeker's chance at success. It's been estimated they are twice to 5 times more likely to obtain the relief sought if they are represented, as compared to their unrepresented counterparts. Next slide, please. So GAIN, we, in addition to recruiting and training volunteers, we provide technical support throughout the process. We provide mentorship, advice. We even attend client meetings as needed. We've also conducted mock hearings or mock interviews for our volunteer attorneys to be prepared for their hearing or the client's interview. In addition to prepping the clients themselves, we also review filings for our volunteer attorneys, and we even co-counsel sometimes. And we often help find expert witnesses, which is also important to support asylum seekers' cases. Next slide, please. So just to give you an idea of some of our current GAIN clients, there's a list there in front of you. For instance, we have a Jamaican gay man that was physically abused throughout his life, and he feared persecution on the basis of his membership in a particular social group, which is a homosexual man in Jamaica. And we also were able to help him with other non-legal issues through our social navigators. That's something that GAIN, we like to take a holistic approach and identify and address non-legal issues with our clients as well. That's why we have 2 full-time navigators that support that process. Also, we have, as you can see listed, other clients and they're all worthy of help. And these are some of our, I believe all of these are in-house clients. Next slide, please. Also, I just wanted to talk about past client victories. Some of these were with volunteer attorneys, with our support. Some of them were in-house cases as well, just to give you an idea of the types of cases and lives that we have impacted, gratefully so. Next slide, please. And if you have any other questions on how to get involved, we're here. My email is scashlin@georgiaasylum.org. I can provide that in the chat. If you ever have any questions about, what we do, how a student can get involved, we appreciate it. And if you're ever interested in a future internship, you can always apply to be our intern. And next up is Carla Diaz. She'll introduce herself, but she's going to be talking to you about T&U non-immigrant visas. Thank you, Carla, for your help.
No problem. Sorry, I was making sure I was unmuted.
Oh, sorry.
Thank you, Serene. That's okay. I'd muted myself. Okay. So I think you all should all be able to see my slides. It says TU non-immigrant visa. So we can get started on that. So like Shelley introduced and Serene mentioned, I am the victims of violence attorney here at GAIN. I do another type of humanitarian relief, T visas, U visas. We also do VAWAs and I-751 waivers. Today we're going to be talking in general about the T and the U visa process. So we'll start off with an overview, and then we'll talk about the specific elements and requirements for each of the type of visas. And then we'll wrap up with some of the inadmissibility grounds that can make you ineligible or a client ineligible, even if they meet all of the other requirements. So let's start off with the overview. So the origins of these visas. So in 2000, the Victims of Trafficking and Violence Protection Act was passed. The purpose was dual. It was to assist law enforcement and to protect and assist victims. So the idea was that victims, especially undocumented or immigrants who didn't have lawful status or permanent status, were not coming forward and were afraid to come forward and report their crimes for fear of being detained and possibly deported and removed, put into removal proceedings. So Congress came up or created these acts to provide a protection for immigrant victims, to allow them to not only help assist law enforcement so they could put the people responsible behind bars, but also say, hey, look, if you cooperate and you participate, you'll be protected. You'll be able to obtain some sort of status, which could eventually lead to permanent status here in the U.S. So this is just an overview comparing the two visas and what they offer and what the requirements are. So both visas are granted for victims of crime. So T visas is granted to victims of human trafficking, and U visas are granted to victims of certain qualifying crimes. And we'll go into the specifics of what those types of qualifying crimes are. Both visas grant status for 4 years. And both visas allow that an individual can apply to adjust status. That means they would adjust status to become a permanent resident after 3 years of having the visa. The T visa does allow for it to be sooner than that if you're able to get a letter from the Department of Justice saying that your trafficking case is over. So they technically won't necessarily need you in the future. So if you're able to get that letter, you're able to apply sooner than the 3 years. Okay, and so both visas also allow you to apply for qualifying family members. If the victim petitioner, if the principal is over the age of 21, they're able to petition for a spouse and for children under the age of 21. And that's for both visas. If the principal applicant is under the age of 21, they can apply for, in addition to a spouse and children, they can also apply for parents and for siblings under the age of 18. The T visa also expanded the protections for qualifying family members to, if the applicant of any age, whether or not they're over or under 21, they can also include parents and siblings under 18. If there's still a present danger of retaliation by the trafficker because the victim cooperated in an investigation. So we have a client now who was able to petition for not only her she's over the age of 21, and she was able to petition for her husband and her 2 minor children. But because her mother had in fact knowledge and was brought to the US at one point to testify against the trafficker, we were also able to petition for her and the victim's younger sister under T6 status. So this extension into these additional family members is also good protection. It's able to allow us to protect a kind of like a family unit from the traffickers and any retaliation from them to bring them to the U.S. So that's not extended to the U visa. The U visa is limited to what you see here. So now, as far as the annual amount of visas that are given each year, T visas, they give out 5,000 visas annually. That number has never been met. I think the most I've seen a year was about 3,000 applications that were submitted a year. So it's never been met. There's always visas available. These are just the numbers that I pulled from 2018 from United States and Citizenship Immigration Services, USCIS. So in 2018, there was a total of 1,600 applications, and of those, 576 were approved. There's still 737 pending, so they haven't made decisions on those. But there was 300 denied, which did surprise me because it seems to be the higher number of previous years. So they're either becoming stricter, doubling down on these types of petitions, and maybe denying more than usual. In contrast, the U visa has 10,000 visas available a year, and they've always met that cap. Since the enactment of the U visa, that cap has always been met. So as you can tell, or as you can see here, there is a very large backlog in U visas. So in 2018, of 34,900 visas that were submitted, 10,000 were approved, and there's still 134,714 still pending. And we'll look at the end on how that impacts waiting times and when an individual can expect to get the actual U visa. So what are the benefits of these types of visas? While the application is pending, a T visa applicant may be eligible to get their work permit, which can allow them to get their driver's license or a state ID. They're given a social security number, and they're also eligible for food stamps and Medicaid and limited assistance. And this is specific in particular to trafficking victim petitioners. And this also comes into play if and when they are given continued presence. So continued presence is given only by a law enforcement agency, whether it's the FBI, Department of Homeland Security. If this law enforcement agency decides to petition for continued presence, they submit the application basically saying that the person is assisting them with an active investigation. So if they're given this continued presence, then that's when these benefits come into play, work authorization and the assistance, the medical assistance and the food stamps. For U visas, unfortunately, that's not the case. While their application is pending, they do not receive any of these benefits unless and if they're given deferred action. So I mentioned the backlog earlier of U visas, which is a very large number. So this means that even if USAS can process a case and they can say, okay, we've looked at everything, you seem to fulfill all of the requirements, you technically should be receiving a visa, but since there's no visas available, you'll be put on the wait list. And while they're on the wait list, they're given what's called deferred action, which makes them a low priority for removal of the US, and it also allows them to get work authorization. So unfortunately, this can still take a number of years to be even placed on the wait list. So until then, they don't really have many protections or benefits. After an application is approved, they're able to receive all of these wonderful benefits in addition to temporary legal status, which can eventually allow them to apply for a permanent residency. Okay, so now we can talk specifically about the requirements and go into detail about each of the visas. So this is just the layout of the statutory layout of what is required for a T visa applicant. So they must be present in the US on account of the trafficking. They must be a victim of a severe form of trafficking. They must have complied with the request of assistance in the investigation of their trafficking case. And they have to show that they would suffer extreme hardship if they were removed back to their home country. And so we'll go into the specifics of each of these requirements next. What does it mean to be present on account of trafficking? This tends to throw off many practicing practitioners, especially if you're newer into the T visa, because on its face, you would think that this means that a person had to be brought into the US or had to have been brought across the border by the trafficker or because of the trafficking. And that's not necessarily the case. The main focus of this requirement is to show that you are currently in the United States because of the trafficking. So whether that means you're still in a trafficking situation, you recently escaped a trafficking situation, you're actively helping and cooperating with an active investigation, or you were brought into the United States to participate and help with the investigation. There's a difference here. So like I mentioned here, there's no border crossing requirement. You could have entered any number of ways. You could have entered on a visa, whether it was a tourist visa or a work visa. You could have entered without inspection, with or without the trafficker on your own. That's not as important as why you're still in the United States now. I also wanted to show the distinction here between smuggling and trafficking. So smuggling is when someone pays somebody to bring them across the border. Usually they call them coyotes or coyote, which is someone that you would pay to help bring you across the border. Now, smuggling can turn into trafficking. So we've had situations where individuals paid somebody to bring them across the border. And then once they were inside the US, the smugglers kept them in a home or decided to make them work or increase their debt and say, now you have to pay me this amount of money before I let you go. And if they didn't have the money, then they were forced to either work it off, either there, or maybe they could get put into the sex trafficking. The idea is that after the initial smuggling, they were then forced to work or pay off an additional debt. So that's where they can transition from smuggling to trafficking. And the parolee just mentions again what I talked about, how a person can be brought into the United States by a law enforcement agency solely for the purpose of participating in the investigation of a case. Okay, so for the next requirement, we have what is severe form of trafficking. So there's the statutory definition, but it basically breaks it down in these types of models. And this is just one type of model. There's other models out there, but it has the same elements pretty much. And we pull these elements are pulled from the statutory definition, which is the one I have listed. So this model is put out by Polaris, which is a human trafficking network. It provides victims who can call and report their trafficking situation, and they're referred to different organizations. So they put out this model, and it touches on the main things. So when you're looking at a situation of trafficking, whether or not it's a severe form of trafficking, you have to have these things. So you have the action, which is how was the person put in the situation of trafficking? Were they induced? Were they recruited? Harbored and transporting, were they actually taken? They could have been kidnapped. They could have been held in a situation. They could have actually been transported into the country, or they're being provided for certain services. So whether it's a seemingly legitimate recruiting or staffing agency or recruiting agency that says, we have this job opportunity for you in the US, it pays this amount, you'll be giving X, Y, and Z. And when they get here, it's not the case, or they're not paid, or they're paid very little, their living conditions are very poor. That's normally what we see in our agricultural cases, is when they're initially recruited in what seems to be a legitimate business. So once you can establish the action, you have to talk about the means. What is keeping that person in that situation of trafficking? So they can be kept there because of force, fraud, or coercion. In the same statute that I have here, it lists the definition of each of these, so it'll go into detail about what is force, what is fraud, and what is coercion. It's also good to note here that coercion can be threats of improper legal use. So a person can say, if you don't abide by the contract, I will report you to the police, or I will report you to immigration and they will deport you back to your home country, or I can sue you, or any improper use of the legal process can be a means of coercion. Obviously, this includes physical force, threats to life, threats to family members, and things like that. And the final thing that you have to show is the purpose. For what reason were you put into the situation? What did the trafficker get out of this? So these are the two categories. We have obviously sex trafficking and labor trafficking. So you have to show that the reason that they recruited you and they forced you to stay in the situation was for some benefit, something of value that the trafficker obtained. Just the note here about minors is that minors in the commercial sex trafficking don't have to show that the means. They don't have to show how they were forced to stay in a situation. It's understood that because they are minors, all of these things can apply, that they don't have the right mindset or capacity to recognize the force or the fraud or the coercion. So they don't have to show that. And then I just wanted to give some examples about labor trafficking, because sometimes it can be our more obscure form of trafficking. It's not as readily known or as popularly known as sex trafficking, because labor trafficking can pretty much exist in any industry. Some of the more common ones that we see at GAIN is agricultural. So we've had people working on tobacco farms, fruit picking, vegetable picking. We've had people working on oil rigs, in the restaurant industry, in the entertainment industry, massage parlors, nannies or housekeepers. It's really a variety. Anything that you can imagine where there could be a power control or can be taken advantage can be considered labor trafficking. Okay. So one of the next requirement that you have to show for a T visa applicant is that they complied with reasonable requests for assistance. So this form I-914 is a certification that's signed by law enforcement or the agency responsible for investigating the trafficking. It's not required for the T visa, and there's no expiration date, which is different from the U visa, as you'll see. Like I said, it's something that's signed by a law enforcement agency, but it can also be a prosecutor or a judge, giving a summary of how the person was a victim and how they cooperated. And again, the exception is for minors and people who have suffered psychological and physical trauma. They don't have to show that they have complied, because we want to keep them protected from being traumatized further. And the last thing to show for T visas is extreme hardship if they're forced to return to their home country. So the way that this is demonstrated is to talk about the fear of retaliation by a trafficker or the network of criminals that he works with. You also want to talk about evidence of any stigma in the home country to victims of trafficking. And tied to that is the lack of services. So a standard thing that we do is we will look up, the U.S. Department of State puts out reports of human trafficking and how each country is combating human trafficking and the services that they provide to victims. So if the victim comes from a country that's not doing very well or not doing much, what they would call a tier 2 or a tier 3 country, we would want to include that report to highlight the lack of services, or how a person could be re-victimized and put back into a trafficking situation because their country is not doing enough or doesn't have the resources to help them or to provide these services. And just note that economic hardship alone is not sufficient. Just because a person can't say that they would suffer extreme hardship only because they don't have the same employment opportunities in their country as they do here. It has to be more than that. Okay, so with that, we'll switch gears into the U visa and talk about what those requirements are and specifics on that. So a U visa applicant must be a victim of a qualifying crime, and they have to have suffered substantial physical or mental harm. And they also have to show that they have been, are being, or are likely to be helpful in the investigation of their crime. So what is a victim? A victim can either be direct, which means that they themselves suffer the harm, or if it's very proximate. It can't be a witness unless you were a witness to a crime and then you were a victim of witness tampering. So if you suffered threats, if the person you were testifying against is threatening you from testifying, then you can seek a U visa because now you're a victim of witness tampering. And on the next slide, we'll see the list of the different crimes that qualify. So in addition to being a direct victim, you can also be an indirect victim. This allows for parents or legal guardians of children or someone who's considered an incompetent victim to qualify for the U visa. So the most common scenario we have is where there is a child who is a U.S. citizen who doesn't necessarily need a U visa because they already have status. So what you have is the parent or the legal guardian who doesn't have status would then be able to get a U visa certification in their name and qualify as an indirect victim for the U visa. They would still have to show, though, that they are being helpful and show how they suffered a substantial harm, whether it's physical or mental. And what are the crimes? So this is a list of the qualifying crimes. The most common ones we see are domestic violence, sexual assault. We've seen instances of stalking and felonious assault, I would say, are probably the most common ones. It's also good to note that an attempt, a conspiracy, or a solicitation to commit any of these crimes also qualifies a person. So if they're a victim of an attempted kidnapping or attempted rape, they would also qualify for the U visa. It's also good to note that the statutory language includes that any similar criminal activity is also included. So again, what we've seen is that armed robbery can be considered felonious assault. So we look at the elements of armed robbery and we say that those elements are similar in the criminal activity to a felonious assault. And we've been able to put forth those petitions and have been able to have them granted. Okay, so the next element we talked about is substantial physical or mental harm. So how do we show this? How does a victim show that they have suffered physical or mental harm? Usually we do this through their personal declaration or affidavit, where we ask them to be specific about how the crime affected them, whether it was physical or mental. We include the police reports or court documents or temporary protective orders. We include affidavits from advocates and therapists, friends or families, all detailing what the harm was that they experienced. USCIS will also consider all of the following factors to determine if the physical harm or mental harm was substantial enough. So they'll look at the nature, the severity of the harm, the duration, and how it impacted the person's life, so their appearance and their health, their lifestyle. And also, like the T visa, you have to show that the person was helpful in the investigation. So they again show this through their personal declaration, from statements of advocates, but more importantly, they must submit a supplement B certification. So when I was an intern at Gain, this was one of the things, and this is one of the things that we ask our interns to kind of help us with now, because it's a project in and of itself, and I'll talk about it more on the next slide. But the U visa certification, you have to have that before a U visa can be filed. Once you get it, you have 180 days to file it. If you miss that deadline, then you have to get a whole new certification, and some agencies may not be willing to sign another one. So it's important that you file before the 180 deadline. So how do you obtain this? Like I mentioned, as an intern at Gain, this is one of the things that I was tasked with, and it takes a lot of advocating and a lot of back and forth. One of the main things you want to do is gather all the documents you already have. So all the police reports, any protective orders that you have, any court documents, if they've already started a criminal case against them. You gather all of that, and then you contact the law enforcement agency or prosecutor's office to determine if they have a process. So most of our urban counties and cities may already have a assigned officer or a victim advocate, and they already know the process. You call them and you say, I have a U visa certification request, where can I send it? And they already have, they give you specifics on what their policy is, who to send it to, how to send it to them, and you would just comply with that. Some of our more rural areas here in Georgia, it's harder sometimes because they have no idea, they've never heard of the U visa. So you are informing them of what the process is, asking them to sign it, explaining to them how they can sign it. So it's going to take longer. Some people you never get responses from. Some people just give you the runaround. Some people, because they don't have a process in place, they're less able to do it. And then some counties and departments already have a process, and they have actually become more narrow and are stricter in what certifications they will sign. So USCIS doesn't have a time frame or a deadline for how long ago a crime had to have occurred, but some counties will say if a crime occurred more than 5 years ago, they won't sign a certification. Or if the crime has not, if there haven't been official charges brought against somebody, or if they haven't been arrested, they won't sign a certification. Although USAS doesn't require any of that. They just need the certification saying that the person was the victim of a crime, that they reported and have cooperated or have not unreasonably refused to cooperate. So it's going to depend on agency by agency, so it's going to take a lot of advocating, and that's definitely something that interns can help with. Okay, and the last bit I wanted to cover was waivers of inadmissibility. So even if you're eligible or a client is eligible and meets all of the requirements for a T and a U, they still have to show that they are admissible to the United States. So certain grounds of inadmissibility can keep them from doing that. So we'll talk about what some of those grounds are and then what options they have to overcome that. So the common grounds are these. These are some of the more common ones we see. There's a full list, and I've provided the statute here where you can see there's health-related grounds, there's national security grounds, there's a longer list of criminal grounds, but these are the more common ones. So false use of documents to enter the U.S., entering without inspection, criminal convictions, prior immigration violations, false claims to citizenship, or helping others enter the U.S. unlawfully. I just asterisk the U.S. citizenship. It's good to note that sometimes people aren't aware that they've made a false claim. They would think, oh, I've never told anybody I was a U.S. citizen. But if you ask them, have you ever used another person's social to work? They'll say yes. And then you have to ask, okay, well, was that person a U.S. citizen? And if they were, that's technically a claim to a false claim to citizenship. So even though they might think that they've never done that, you have to just have those follow-up questions to make sure. So what if they've triggered a ground? What options do they have? So the T and the UVs in particular are very, very generous. The statute and Congress has allowed for these waivers of these grounds of inadmissibility, and that's through the use of Form I-192. The purpose is to allow them to have advance permission to enter, and that's not literal. That doesn't mean that they have to exit the U.S. and enter. That means they can do it from inside the U.S. It just means that they are now forgiven any inadmissibility and have become admissible to the U.S. The standard that they look at is for the national public interest. So they grant these waivers in the interest of the public, and it's either to protect victims or to get the bad guys off the street, right? I've provided the two statutes here for going into more detail about what they waive. The U visa waiver pretty much waives everything except for national security issues. Factors that USCIS considers when they want to grant these grounds of inadmissibility is if you can show that the person is being rehabilitated, mitigating factors, whether they have U.S. citizen children or people who are dependent on them, their ties to the community, lack of access to services in their home country, or specific circumstances surrounding their acts. So if a person is a victim of human trafficking and they were involved in prostitution, which is potentially a ground of inadmissibility, they would explain that they were only involved in prostitution because of their victimization in human trafficking. So that would waive that ground of inadmissibility. Okay, final tips. I think we're cutting short on for time for Q&As, but these are just general tips for the waivers. You want to be specific but general. I know that doesn't make sense, but basically what you want to do is be specific in what you're requesting to be waived. We usually refer to the exact statutory ground. We'll put the statutory number or the statutory language. So we'll be specific on what ground we're asking for, but we're general in providing the details. So we don't want to give more details than necessary. So if a person is convicted of robbery, maybe we don't want to give the police report because the police report paints your client in a very negative light. So that's not necessary. They just need to know that they were convicted and what steps they've taken to rehabilitate or become better. And so that's what we mean by being specific but general, and then balancing the equities. And then just a reminder about, disclosing. If you don't disclose, it's not waived, and that could cause problems down the line. So this is just an overview of what to file, the forms that need to be filed, whether you need a waiver or not. We've already discussed most of these. And overall tips: using recent versions of the forms. Translations must be accompanied by all foreign documents must be translated. They don't have to be by a certified translator. You just need to have a certified, a translator certificate saying that you're competent. There's also a new memo real quick about leaving blank spaces, particularly for U visa applications. They've started rejecting any application that has a blank field that's not optional. So if, for your example, your client doesn't have a middle name and you left that field blank, they could potentially reject the whole application because of that. So just being aware of that new change in their processing of U visa cases. Timelines. Just the last note here I wanted to have is, given the estimated, the pending cases for U visa applications or petitions, people are estimating that it can take 10 plus years for a U visa immigrant to receive their status, which is a very significant number. So 4 to 5 years for them to possibly be placed in deferred action, which could get them a work permit, but it's unknown, or it's estimated that it could be 10 or more years for the actual U visa. I will leave you at that. If you're interested in volunteering or contacting us, like Serene said, there's my email, and I can also put that in the chat.
Awesome. Well, thank you guys so much for that presentation.
Sorry, I rushed towards the end there. I didn't.
No.
I
know we got at least one question about how people from Central America seeking how are people from in this moment of MPP able to seek asylum with this new Remain in Mexico policy?
Right, and that impacts people that are presenting at the border, the southern border, and so it's basically allowing officers to turn back people and let them basically wait in Mexico while their asylum case is pending. So they are able to still apply, but it's a hurdle for asylum seekers. And honestly, I haven't dealt with it firsthand myself yet because it hasn't impacted any of my clients. But I know that it's being challenged in court, and the ACLU and other organizations are challenging that policy in court because it's putting people in dangerous situations at the border.
I know at Tahare we do have one MPP case where we have pro bonos, and yeah, having your individual hearing, it makes it hard to get representation. We have pro bonos, but they're going to have to video conference in or teleconference in. You have MPP plus COVID-19, so it's a very, very difficult situation right now. I wanted to pick your brain, if I can. We have an upcoming asylum hearing, and I know you talked about, committing crime, like if you've committed a crime or committed any sort of, been a part of any sort of terrorist organization. We have a client right now who was, kidnapped and sexually abused by a sicario in Honduras. And when she fled, she ended up picking up some drugs and just wasn't thinking and grabbed a bag of drugs and, ended up giving them to someone who sold them. And so, this is a huge hurdle. Like, oftentimes our clients are forced into doing things that they wouldn't otherwise even think about doing. What are some techniques you have to overcome some of those types of barriers where, she wasn't charged or arrested, but that's a part of her narrative that we have to kind of be open about? And what have you seen those types of situations, and what have you done in those situations?
The person that sold it, were they involved in the terrorist organization themselves?
No, they were a neighbor.
Yeah,
it was just someone that she knew.
So she basically just stole from the organization. I don't see it as, I would have to do a little digging and look at the actual language, but I remember, for instance, a woman that was forced to cook for a terrorist organization that was considered material support. Whereas your client is fleeing like sexual abuse and she stole something on the way out. I don't know if that's this. It sounds different to me. I think you just have to try your best to clarify that it's different, that it doesn't fall under that bar. I think that's the best technique I can think of.
Yeah. We have another question about who conducts the credible fear interview.
Oh yeah, the officers, the immigration officers at the border. Sometimes they send asylum officers too, to the border to conduct these interviews. Um, but yeah, if they have a credible fear, they express, they're afraid to return to their home country, why they're afraid, then and they pass that interview, they believe they're credible, then they can be put in proceedings instead of deported. And a majority of our cases are affirmative, but I feel like there's so many more defensive cases right now. Like, and I don't know, it's
Yeah, I think right now the majority of our cases are defensive, to be honest.
they might be equal by now. I think I'm really
Yeah,
getting, honestly, I'm getting more defensive than
yeah,
affirmative. So,
yeah.
yeah, there's
Does
a lot of.
anyone else want to go on unmute, ask any other questions of our two experts? Well, I want to thank you both so much. I mean, this has been really informative, for me even, because I just joined Tahare and I've done maybe 3 asylum applications now, so it's always good to get a refresher. And I know all the folks attending really appreciate it as well. So thank you for taking the time to speak with us today.
It's our
No,
pleasure.
thank you. Yeah, thanks
So
for putting it together.
Yeah, absolutely. So tomorrow, for those of you that are still online, at 11 o'clock on the same link, we're going to have Ariel Prado and Alia Nayem from Innovation Law Lab, and they run a pro se workshop once a month, and they've been doing it virtually to help pro se asylum seekers. And so this is actually a really great opportunity for folks that are interning this summer to interface with asylum seekers. They usually need someone to get all of the Part A information. Tell me all your siblings, where do they live, where were they born. A lot of detailed information is needed, and so it's a great way to get involved with the community here. So they're going to be presenting at 11 tomorrow. And then Lynn Pearson from Tahare runs our appellate project, and so she's going to be talking about immigration appeals tomorrow at 2 o'clock at the same link. So I hope some of you can join us then. We're going to have this recording available. I'll share it with folks on YouTube. And so, if anyone in your organization is interested in hearing the presentation from today, we'll have that available online. So with that, I'll thank you. I'll stop recording and we can go forth and fight for the good fight.
Yes. Thank you everyone for listening.
And thank you all. Bye bye.